Now, as Justice Barrett wrote in the opinion of the court, this case was incredibly important. The question whether Congress has granted federal courts the authority to universally enjoin the enforcement of an executive or legislative policy plainly warrants our review. It is easy to see why. By the end of the Biden administration, we had reached a state of affairs where almost every major presidential act was immediately frozen by a federal district court. The trend has continued. During the first 100 days of the second Trump administration, district courts have issued approximately 25 universal injunctions. As the number of universal injunctions has increased, so too has the importance of the issue. Imagine that. A nation not ruled by laws but by judges. How is that any different from the very first grievance our founding fathers brought against the king in the Declaration of Independence? That he has refused his assent to laws the most wholesome and necessary for the public good. Now, we declared independence from Great Britain for overturning our laws, so why should courts be granted the same power? The fact is, they weren't. The government is likely to succeed on the merits of its argument regarding the scope of relief. A universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. It's important to remember that, other than the Supreme Court, all other federal courts are created by, and therefore regulated by, Congress. From Article 3, Section 1 of the Constitution, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may, from time to time, ordain and establish. So where do these inferior courts get their power from? Congress. In this case, the Judiciary Act of 1789. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits in equity, and still today, this statute is what authorizes the federal courts to issue equitable remedies. Though flexible, this equitable authority is not freewheeling. We have held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. Now, many of our legal traditions come from our mother country, Great Britain. So when the court asked the question if universal injunctions are the sort of equitable remedies traditionally accorded by courts of equity at our country's inception, they're looking back at the High Court of Chancery in England. We must therefore ask whether universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act. The answer is no. Neither the universal injunction nor any analogous form of relief was available in the High Court of Chancery in England at the time of the founding. Now, while Justice Barrett went into great legal detail when she wrote the opinion, the short answer is there was no power of universal injunctions at the founding of the nation. Justice Thomas brought this out during oral arguments.
So we survived until the 1960s without universal injunctions.
That's exactly correct.
There were a few concurring opinions, but they focused on legal details. Important, yes, but beyond the scope of this episode.